Joining us now, MSNBC's Kevin Frey, and he has been following the political implications of this case from Capitol Hill, and Justin Levitt, professor of law at Loyola Law School. And Kevin, this is a very consequential case. What's at stake here?
Yeah, I mean, look, at the end of the day, this is looking at whether or not to uphold Section 2 of the Voting Rights Act, and essentially whether or not these districts that are drawn as majority black, majority minority, can stand under the Constitution. And up until the most recent election, Louisiana actually took a step to ensure that there were two districts in the state that basically met those sorts of standards. It is about 1/3 of the population in Louisiana is black. This creates two black majority districts, one in Louisiana, one in New Orleans, one stretching from Baton Rouge up to Shreveport. The big question here, though, is if the Supreme Court, which heard this case previously, punted it to this current term, if they decide to gut that aspect of the Voting Rights Act and overturn, for example, the maps in Louisiana, that could have ripple effects in states across the country. You could see GOP-led states look to redraw their maps as well. We're already seeing a redistricting battle play out, most notably between Texas and California. If you see other states follow through, that could lead to presumably more Republican-held districts, and that could undermine efforts by Democrats to win back control of the House of Representatives, which, of course, is their key aim heading into the midterms in just over a year.
Kevin, thank you so much for your reporting. And Justin, you filed an amicus brief in this case being heard today. Can you explain your argument to our viewers?
Sure. I mean, the argument is that this 60-year-old precedent, the Voting Rights Act, and the rules around the Constitution are easy to follow if you're trying. Basically, the court is asking how much entities can consider race in the redistricting process, whether it's constitutional at all. Their answer for 60 years has always been maybe, a little bit. The way that you consider race can be unconstitutional, but it's also possible to consider race in a way that fights discrimination. And Congress has the authority, the very clear authority under the 15th Amendment, to decide when we can combat discrimination and how. For the court to go back on that today and in the months to come, I think would undo 150 years of jurisprudence about what powers Congress has, which is really what this case is about.
Now, this case, as you were mentioning, centers around Section 2 of the Voting Rights Act, which prohibits discriminatory election practices based on race. The critics here are arguing that redistricting should be colorblind, that the 50-year-old law is somewhat antiquated, and we don't need this to protect black communities because segregation is no longer in effect. What's your response to that?
A couple of responses. First of all, the law that we have now, the jurisprudence we have now, comes to us through Justice O'Connor. She was the last justice to sit on the court who actually went through the redistricting process, did it 3 times. No other justice has actually drawn lines since. And what she knew as a practical matter is that you can't unsee race. Redistricting is about drawing communities. It's about representation for real communities, and legislators know who those communities are. Even independent bodies know who those communities are. So race, she understood, is always going to be in the mix. The second thing I'd say to those critics is that the Voting Rights Act has been caricatured. It's an anti-discrimination statute. It doesn't exist to give racial entitlements. It doesn't exist to draw districts every time there's a group of minority voters. It's designed to combat discrimination and to make sure that discrimination in the electoral process and discrimination beyond the electoral process doesn't spill over into politics. It doesn't apply wherever there are minority voters. It only applies where there are vestiges of discrimination that need to be rooted out. And that's exactly why Congress has the power to make sure that we don't have discrimination in voting elsewhere in the country.
So if the court does undo some of the core tenets of the Voting Rights Act, it could mean that Republicans gain 19 seats, as we were hearing there from the reporting at the top in the House. That's on top of the seats that we've already seen in some of these redistricting efforts underway in places like Texas. What could be the longer-term impacts or precedent that this would set beyond just the upcoming midterms and for both parties?
Yeah, this is a big deal, and you're right, for both parties and long term. There are about 19 seats that would be in play in Congress. But well beyond that, this portion of the Voting Rights Act does most of its work in state legislative seats. It does most of its work in local districts for city council and county commission and other local municipal offices. The Voting Rights Act has been one of the most successful civil rights statutes ever passed because it puts all of the people back in control of how how they're represented. And if the court decides to upend Section 2 of the Voting Rights Act, to upend this really key provision, then that's going to mean free rein for discrimination, not just in drawing congressional lines, but in every level of representation we have. That's a really big deal.
All eyes will be on SCOTUS today. Justin Levitt, thank you so much for your perspective. We appreciate it.